Good morning. Welcome to this special session of the 1st District Court of Appeals. Thank you to Walnut Hills High School for the invitation. We will be hearing 3 cases this morning. I will call each. The first is case number C-24-0539, State of Ohio versus Christopher Harris, and I see counsel is present. Are you ready to proceed?
Yes, Your Honor. Ready to proceed.
Your Honor, I'm ready to proceed for the state.
Thank you. The second case is C-25-0200, State of Ohio versus Kelvin Henry, and I understand counsel is present and ready to proceed. Is that correct?
Yes, Your Honor.
And is counsel for the state present?
Yes, Your Honor. I have that one.
All right. Thank you, Mr. Springman. And then lastly, case number C-25-0148, Henry Guardianship of Dixie Faust. Is counsel present on that case?
Yes, sir. Good morning, yes.
All right, thank you. All right, we will begin with C-24-0539, State of Ohio versus Christopher Harris. Would you like to reserve time for rebuttal?
Yes, Your Honor. 4 minutes, please.
All right, give me just 1 moment to set up my timekeeping system here. You may begin when you're ready.
Good morning, Your Honors. Margaret Kane on behalf of the appellant Christopher Harris. Numerous prejudicial errors underlie Mr. Harris's conviction in this case. However, for purposes of argument today, I will be focusing on the first 3 assignments, starting with the third assignment of error, first issue presented. Before the parties even gave opening statements, Mr. Harris was denied his right to a fair trial by an impartial jury when the trial court precluded defense counsel from asking any questions regarding racial bias during voir dire.
Was he prevented from asking any questions, or did he ask some and then was he cut off?
He asked one question and was promptly cut off by an objection from the state when he tried to follow up after a juror had responded that essentially they had had some negative experiences with an individual who was black.
Now, was he cut off when he was asking questions about racial bias or this concept of implicit bias?
He was cut off during his discussion of racial bias specifically. He did, prior to that, have an opportunity to talk a little bit about implicit bias. Now, this issue was very recently addressed and decided by the 6th District Court of Appeals in State v. Bellman. In State v. Bellman, the 6th District determined that the trial court abused its discretion and committed prejudicial error requiring reversal where it prevented inquiry into the topic of racial bias.
And that was any inquiry whatsoever, correct?
In that case, actually, the defense counsel got out a few questions regarding racial bias, but was cut off shortly thereafter by the trial court. And in that instance, the 6th District determined that defense counsel should have been given the opportunity to continue its inquiry into racial bias with the prospective jurors.
But in that case, the court determined that because the victim and the defendant were both black, then race should not be an issue. Is that right?
So in that case, the court determined, the trial court, are you asking?
Yes.
Yes, so that the trial court in that case, much like this case, determined that because both the defendant and the victim were black, race doesn't matter. However, the 6th District correctly held that even in cases where both the defendant and the victim are black, racial bias may prevent a juror from being impartial, and cross-racial crime is not a prerequisite for racial prejudice.
But that's not really what happened in this case, because in this case, the court said, you know, you're not going to lecture the jury on issues of race. Counsel was talking about kind of concepts about, I think they were using some diagram, but they weren't cut off about any discussion of racial bias. Is my understanding correct?
No, actually. So the trial court did become frustrated when the defense counsel was questioning regarding implicit bias. However, it wasn't until he got into the issue of race that he was cut off. And
this interaction between the defense attorney and the court, when the defense attorney was shut down, occurred just after juror number 7 disclosed that, and I'm not sure if this was a male or female, but I think it was a female actually. Juror number 7 disclosed that she had a history of working at restaurants and that she had found her interactions with customers of color to be scary in that setting.
Correct. So the court shutting it down did occur right after that juror had indicated those experiences. And so...
Was there ever any follow-up with that juror about her disclosure of those feelings?
There was not. So...
Do you know counsel have the opportunity to individually interrogate jurors? Could that have been asked if he had returned to juror number 7?
So he, in his effort to try to follow up with that juror and with the jury pool, that is where he was cut off multiple times in a row, and that was when he agreed that he would move on from the topic. And so the trial court precluded that continued examination to assess whether or not that juror or any of the other jurors would be unable to be impartial based on either explicit or implicit racial biases. And so for those reasons, we ask that, similar to the 6th District, that this court also reverse and remand for a new trial based on the foreclosing of the opportunity to ask questions regarding race during voir dire in this case. In addition, we ask that this court reverse Mr. Harris's conviction for aggravated murder, as there was insufficient evidence as to the element of prior calculation and design.
On prior calculation and design, didn't he go back towards his house and pause? And isn't that enough to establish prior calculation and design? Isn't there at least an inference of a moment of thought to return to the confrontation?
So, Ohio courts have held that momentary deliberation is insufficient to establish prior calculation and design. And regarding Mr. Harris walking up towards his porch and then returning, there is also evidence in the record that suggests that the interaction between Mr. Harris and Mr. Williams never ended. The two men continued to go back and forth. This wasn't a termination of the interaction and then the engagement. It was simply a movement of place where the engagement was continuing. So when assessing whether or not there was prior calculation and design, courts usually consider 3 different factors. The first factor is one that we don't need to discuss today because the state has conceded that Mr. Harris and Mr. Williams did not have any prior relationship. As to the second factor to consider, that factor is whether or not Mr. Harris, whether the evidence suggests that Mr. Harris gave any forethought to the weapon or to the site of the homicide in this case. And the evidence does not support such an inference. It is undisputed that the firearm that Mr. Harris possessed at the time was a firearm that belonged to his wife, and that when she exited the vehicle that they had pulled up in, she inadvertently left the firearm in the car. Mr. Harris removed the firearm to prevent leaving it in the vehicle overnight and put it in the front pocket of his sweatshirt. So there was no forethought about using this firearm for the purposes of homicide, but really the evidence indicates that he had...
But counsel, aren't these factors non-exclusive? I mean, in defining prior calculation and design, we're not bound by these 3 factors alone, are we?
So these 3 factors are part of the overall analysis, and so it's taking into consideration these factors to help guide how you determine whether or not there was prior calculation design. So there's not one that controls, but they're all relevant to that analysis. And so the second portion of that second factor is the choice of murder site. And there is a case that is instructive on this very issue that came out of the 8th District, State v. Woods. And in that case, there was an individual who brought a woman home to his
Is there any evidence that he was thinking about this camera during the night of the shooting?
No, there's no evidence that
And he was intoxicated as well, right?
there's no evidence that he was intoxicated.
The video doesn't show him kind of stumbling out of the car?
So he offered an explanation for that, and I don't think that the video is conclusive as to that. He indicated that he had one drink, that he was trying to adjust his shoe, and that was what caused him to stumble back a little bit. There was evidence that the decedent was highly intoxicated at the time, but the same type of evidence is not presented for the defendant.
And counsel, you're out of time.
Okay, thank you very much, Your Honors. We ask that this court reverse, and I'll reserve the remainder of my time for rebuttal.
Thank you.
May it please the court. In this particular case, differs markedly from the supplemental authority and Bellman that defense counsel is referring to. First of all, in Bellman, the defense counsel was only given a chance to ask 3 quick, simple questions to delve into confirmation of racial bias and was completely cut off. The voir dire in this case, which spans some 400 pages, demonstrates quite clearly that the trial judge allowed defense counsel the opportunity to delve into both racial bias and confirmation bias at length.
Well, counsel, what about the interaction that I described? So, from my reading of the transcript, defense counsel was permitted to ask the jury a question about any negative experiences that they may have had with Black people. And juror number 7 disclosed that she worked in restaurants and that she had had some scary, that's her word, interactions. And it was at that point that the defense attorney was cut off. And so there was never any follow-up with that particular juror who wound up serving on the jury about the nature of those feelings. Can you address whether it was proper or improper for defense counsel to be cut off in attempting to respond to the juror's disclosure?
I think the context of the cutting off there was, it wasn't to the point where the trial judge was not going to permit defense counsel to continue to probe into that particular subject matter with that juror. My understanding is throughout this reading and rereading of the voir is the trial judge exercised extreme patience and gave defense counsel extreme leeway to delve into racial and confirmation bias, including the juror 7. I can't explain why defense counsel did not follow up with juror 7.
So that goes to a little bit to my question. Do you think that the defense counsel should have done something more to preserve? Should he have asked for a sidebar about the colloquy about race, or should he have delved deeper with the individual juror? Do you think he just failed to follow up or maybe even failed to preserve the error?
Defense counsel may have failed to follow up, and the reasons we don't know, and that's the thing, is when we're sitting and reading the transcript, we don't get to observe the actions of defense counsel in asking questions. How juror number 7 answered, what the body language was. Perhaps defense counsel was maybe somewhat satisfied with that answer based on body language, but on its face, I can't explain on this record why defense counsel did not follow up. I just know that the trial judge exercised extraordinary patience, gave defense counsel extraordinary leeway to delve into these issues, and I don't see why the trial judge would have prevented defense counsel from following up with juror number 7.
Now, defense counsel had an opportunity to strike juror number 7 and any other jurors using these peremptory challenges, correct?
And that's correct, Your Honor. That's
And
the
then
second part.
defense counsel didn't exhaust all of his challenges.
That's correct, Your Honor. So there must have been something there, something that defense counsel liked in viewing juror number 7's questionnaire, or perhaps the way the juror's body language was when the juror asked that question. But it's certainly not reversible error when the trial court was very patient in this area and made sure to give defense counsel significant leeway to ask questions on racial and
But
confirmation.
why is this not like Bellman? Because in Bellman, defense counsel asks the potential jurors if any of them get nervous or apprehensive when interacting with a black person. At least one juror raised their hand, and then the trial court cut off the defense attorney and said, we're not turning this trial into race. And then the defense attorney was never able to follow up with the juror who raised their hand. Why is the interaction with juror number 7 in this case, who said she found black people at restaurants to be scary, and then defense counsel got cut off and was never able to follow up on that? Why is this not the same as Bellman?
2 reasons. Your Honor, the way I read this record is, first of all, in Bellman, only 3 questions was defense counsel allowed to ask to delve into confirmation of racial bias. Here, the judge gave much more leeway to defense counsel to delve into this issue, not just 3 questions.
And so it's what came before? It's what preceded
Well-
the person raising their hand and juror 7 giving her answer?
Well, when juror 7 gave that answer, defense counsel had not only the opportunity to follow up, but could have followed up, unlike in Bellman, but could have used a peremptory challenge to strike juror number 7. So I draw the inference that there was some reason why defense counsel wanted juror number 7 on that jury. It wasn't because the judge was trying to limit questions about racial or confirmation bias at all.
As I understand the law, though, the adequacy or inadequacy of voir dire is untethered from the use of preemptory challenges, because an attorney can't make effective use of preemptory challenges if they don't have the ability to suss out information from prospective jurors. That's what voir dire is for, is to ask questions and learn about the prospective jurors to understand if you want to keep them or not keep them.
Your Honor, that's correct. And we could have voir dires that go on and on and on and never have a limit to it. But here, there was a possibility for defense counsel to follow up with juror number 7. And that's what makes it so difficult.
Why is that when the trial court already sustained the objection and told defense counsel that he was not permitted to lecture the jury based on race? How would defense counsel have then been able to follow up on the disclosure of racial prejudice?
I believe the opportunity was there because in my reading of the record and all the patients, I wouldn't call it patients, but the trial judge allowed defense counsel so much latitude to delve into this that I am sort of just don't understand why defense counsel didn't ask that question or follow up. I think the trial judge was just concerned with the specific question and where counsel is going and kind of veering well out of the lane and was trying to just bring the voir dire back to the focus on racial and implicit and confirmation bias. I think that was the judge's intent to do that.
So it's your position that, I just want to make sure I understand, it's your position that even after the objection was sustained, the defense counsel still could have come back and asked juror number 7 additional questions about the restaurant?
That's the, again, we're reading a cold record. That's the vibe I get, just because it's not like Bellman. The judge allowed defense counsel to put up a triangle, use demonstrative evidence to delve into racial and confirmation bias. And
So the defense attorney specifically talked about implicit bias, and these questions, this particular juror seem to be focused on race. Do you know that the Hampton County jurors, do they get any kind of implicit bias training before they enter that trial court?
You know, Your Honor, I'm not sure about that. I would hope that that would be incorporated into the juror training, that they would be explained about implicit biases, and stereotypes that can be formed.
And do you think if the defense attorney had taken the issue of race explicitly out of his question, could the defense attorney have said, juror number 7, tell us a little bit about what happened when you were working at that convenience store so we can understand if that makes you unfair or impartial in this particular case?
Yes, that's what I don't know why defense counsel didn't do that.
Do you think
And I don't
defense
know.
counsel voluntarily moved on?
I can only draw that inference because defense counsel didn't use the peremptory challenge on juror number 7. So there must have been some reason why defense counsel wanted juror number 7. And I understand what Judge Kim was saying about the law, but this just is not like Belmont. It was just so... Three questions and it was just cut off completely, and this judge didn't do this.
And there are some first district cases on the same issue. The 1984 case, the State v. Jones case, was a complete cutoff.
Yes, that was a complete cutoff, and this is just a far cry from a complete cutoff. This was, allowing, defense counsel just wide latitude to go into those areas.
And 400 pages, do you know, was that more than a day of jury selection?
Yes, it seemed to be more than a day of jury selection. I should have checked that, but it was long. And, I know since it was a simple issue, it took a long time to read it a couple of times, but it just, I don't want to use the cliche, it just didn't strike you as a judge that wanted to cut off questioning in this area just because it was sensitive.
Now, you talked about this area, and we've heard the terms implicit bias, racial bias, confirmation bias. Are there distinctions between those types of biases?
Yes. I mean, I look at implicit bias is unconscious attitudes and stereotypes that people form towards social groups. It could go beyond race. And your confirmation bias is interpreting situations consistent with a person's existing beliefs. And that affects decision making oftentimes when people engage in confirmation bias and implicit bias. And that's the problem because jurors are making decisions. That's why certainly counsels should be asking those questions. That's why hopefully the jury commissioner does give a video to jurors about implicit bias and confirmation bias. And you're taught to overcome confirmation bias in a number of different ways. One is to look at different viewpoints. One example, I'll just use guns. If you're a real gun control advocate, you might just read material that supports your position and not read material from the NRA. The opposite is true. If you're for the use of guns, you don't just read NRA material. If you read other material, you consider other viewpoints. You try to do self-reflection to see if maybe you're wrong, and because you've just gotten a source of information from one biased area. And those are ways that you overcome it. And I would hope that that's what the jurors get when they serve on the jury duty, so they can recognize both confirmation bias and implicit bias.
As to prior calculation and design, I did have a question.
Yes.
Was he charged in the alternative with a lesser included offense, or was there a request for a lesser included offense to eliminate the prior calculation and design element of aggravated murder?
Usually we do that, and I now, I wrote to you brief in between. I can't remember, Your Honor. I should. I can't remember the jury instruction. If they were the jury instruction. Usually we do, but I wish I could say it for certain. But here, the video tells it all. I know that I'm technologically challenged, and that's why the footnote is in here. So before you're much better than I am, but you can actually slow the video down, which is in color, and then hone in on the entire actions and how much time went by from when the defendant stepped off the porch, went to his car, held an object up 3 times in the direction of the victim, and then later kind of walked fast and jogged towards the victim and emptied the 9mm pistol, which presumably the jury would infer was taken from the car. And so there are 15 shell casings, I think, that were found, or bullet fragments that were found. And so he emptied the gun at CW. And so all of that, to me, suggests prior calculation and design.
Counsel, you're out of time.
All right, thank you.
Thank you very much.
This case involved one of the most serious possible deprivations of liberty. Mr. Harris was charged with aggravated murder and faced a potential life sentence in prison. Because of that, he should have been granted a great deal of latitude during voir dire to assess whether or not the jurors had any biases that would prevent them from being impartial. Regarding the state's representations about State v. Bellin, those representations are incorrect. While it is true that the attorney in State v. Bellin had the opportunity to ask 3 questions about race, that is 2 more questions about race than defense counsel was afforded in this case. And in State v. Bellin, the trial court explicitly stated that defense counsel was not being barred from asking questions about implicit bias, but was only being barred from asking questions about race.
Counsel, I'm looking at the transcript of voir dire, and after juror number 7 talks about her encounters with black folks at restaurants and saying it was scary, defense counsel says, I'd like to share something more with you, if I could, and then that raises the objection. So he wasn't following up with any, at least according to the transcripts, any specific questions about juror number 7's concerns with her encounters with black people at restaurants. Am I reading the transcript correctly?
So that is, of course, the direct framing or phrasing of how defense counsel was starting to get into the next question. Defense counsel then did try to explain that he was going to be asking questions to pull out more information about race, and so he wasn't given an opportunity to be able to do that. And so I think that in this instance, much like in Bellin, it was a complete foreclosure, which courts in Ohio have determined is an abuse of discretion.
What if he was asking more questions about triangles? Could that have been cut off?
So the court made very clear in its continued, in its explanation that it did not want defense counsel to ask additional questions about race, and similar to the court in Bellin indicated that this wasn't going to be a topic of conversation.
But
my understanding is that he basically said, I don't want this to be a lecture on race. And my understanding of voir dire is, if there's something relevant from what a particular juror says, you can return to that particular juror, and rephrase the question. It seems like counsel could have rephrased the question to inquire about a particular incident at the location of the business.
I believe that defense counsel could have done that. However, I don't believe that he would have been able to engage in further questions regarding racial bias, which is the abuse of discretion in this case.
But the court goes on to say you're supposed to question the jurors to see if they are going to be fair and impartial, not lecture them about race. So would that indicate that if he was asking questions about the jurors' ability to be fair and impartial, the court would have allowed that question?
So I think that there's a complicating factor here, which is that in order to assess whether or not the jurors are going to be fair and impartial, defense counsel had to be given the opportunity to ask questions about racial bias specifically. There is a large body of research that shows that jurors, much like the general populace, are not immune to racial biases, but in fact hold racial biases that have significant impacts on the way that they view the accused, as well as the way that they interpret the evidence. Research also shows that one of the best ways to combat that type of racial bias is to make race explicit rather than implicit, to talk about it. And those research studies are included in our brief.
Counsel, you're out of time if you'd like to wrap up.
All right, thank you very much. We would ask that this court reverse the conviction in this case. Thank you very much.
Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely written decision. The second case on our docket this morning is C-25-0200. We'll give the attorneys just a moment to get settled. You may come forward when you're ready. Would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes.
You may proceed.
Good morning, Your Honors. Mr. Sherman, may it please the court. Jessica Moss on behalf of the appellate Colin Henry. This case is about self-defense. The trial court here determined that Mr. Henry, as well as MD, the person who was hit, were the two innocent people involved in this situation, and that they did not intend to get into a fight. Mr. Henry's purpose was to prevent a physical altercation from happening between Ms. Green and Ms. Reynolds.
How was that accomplished by driving the one combatant to the scene?
The person referring to Ms. Green, who was pregnant at the time, Ms. Reynolds had gone over to her house earlier that day, threatened herself, her unborn child, and her son. And Mr. Henry, along with Ms. Green and another individual who was driving the car, went over there simply to talk to Ms. Reynolds to try to de-escalate the situation.
How was going into that situation going to de-escalate it?
The testimony at the trial was that Mr. Henry was trying to explain that Ms. Green somehow got wrapped up in whatever this text message dispute that initially started, what was happening with Ms. Green and Ms. Reynolds, and with a third person in that text message exchange. But to try to calm the situation, Ms. Green was terrified for herself and her child, her unborn child. In this case, although Mr. Henry's purpose was to prevent any kind of physical altercation, the circumstances culminated where Mr. Henry had to protect himself from a perceived threat from Ms. Reynolds' brother. And in here, the only assignment of error concerns the trial court's rejection of Mr. Henry's self-defense claim. And the state is not contesting that Mr. Henry met his burden of establishing a prima facie case of self-defense, and that the burden shifted to the state to disprove self-defense beyond a reasonable doubt. And here the state did not disprove any element of self-defense beyond a reasonable doubt. And this case is distinguishable from many self-defense cases where the trial court finds the victim credible and the defendant not credible. The trial court here made a specific finding that Ms. Reynolds was not, with human here lying was not credible. But the trial court also made a finding that many of the witnesses who testified were not credible. And only 4 witnesses testified at trial. 3 for the state, Ms. Reynolds, MD, and Officer McKay, and 1 person for the defense, Ms. Green.
Was there any specific finding about MD's credibility?
There was not any specific finding about MD's credibility, but
So, as between the 2 people involved in the fight, isn't it a reasonable conclusion that the trial court found MD's testimony more compelling and believable than Henry's?
I don't think so. By using the word many, the trial court signifying that more than 2 individuals were not credible, and it's likely the trial court viewed in terms of Ms. Reynolds, MD, and Ms. Green, several portions of their testimony not credible. Likely in regards to Ms. Reynolds, the fact that Mr. Henry allegedly claimed that because he could not hit Ms. Reynolds or another female, that he was going to hit MD. Ms. Reynolds never reported that to police and reported that for the first time at trial. The testimony from Ms. Reynolds that MD was hit 3 times, which was refuted by MD himself and Ms. Green. As to
Does that matter, though, if the trial court believed MD?
I don't, again, by using the word many, I don't know that the trial court believed all of MD's testimony, when the court also found that Mr. Henry was one of the 2 innocent people.
When you say that, is there some explicit finding, or was that just something he said on the record? He didn't really specify who the 2 innocent people were, did he, the trial court?
The trial court did. I believe that was on page 92, that it was Mr. Henry and MD, the 2 innocent individuals that did not intend to get in the fight.
Now, before he was struck, is it accurate that MD had his back to Mr. Henry?
I think that is one of the findings that I don't know that the trial court believed. There was tensions certainly were high once MD came outside. Before MD came outside, nothing physical had happened. By MD's account, he had his back turned.
In an effort to keep his people back and maybe move them towards the house and away from the encounter. Is that correct?
He was trying to, he was testimony, he was trying to move his sister back. The trial court found that MD was trying to get his sister inside because he knew his sister, Ms. Reynolds, liked to fight.
And then Mr. Henry grabbed him by the shoulders and turned him around.
And in that part, I don't believe that the trial court found was credible by also finding that Mr. Henry was one of the innocent people here. If the trial court would have believed that Mr. Henry actually turned MD around, I don't think that the trial court would have made that specific finding. When we look at...
Well, doesn't that statement, though, there were 2 innocent people here, doesn't that go to the beginning of this whole kerfuffle? Wasn't the trial court observing that this started as a fight between 2 women and that Mr. Henry and MD got pulled into it? I don't think the trial court was describing what happened when MD was hit.
My interpretation of the court's finding is that the court was making that finding. Here...
How do you reconcile that, then, with the trial court also finding Henry guilty?
What I think that the trial court turned on the decision on is the second element of self-defense, the reasonable basis, and specifically the objective component of that test. The trial court found that Mr. Henry believed that there was prosecution, but was not sure that that was clearly shown. And because in the last 5 years that the burden, with the new burden shifting analysis, the burden was on the state to disprove self-defense beyond a reasonable doubt, the fact that the court was not sure if it was shown would show that the state did not disprove that element beyond a reasonable doubt. And it was reasonable here for Mr. Henry to believe that in that moment in time, there would be a reasonable, imminent risk of reasonable harm from MD.
What facts would establish that objectively reasonable perspective? Because, as described in the transcript, it doesn't seem like it was reaching that point of confrontation. It seems like perhaps Mr. Henry reacted too quickly.
Well, in the second component of self-defense and this reasonable element, that incorporates potential mistakes as to imminent risk of harm. There still has late at night. Mr. Henry and MD did not know one another, and Mr. Henry initially asked MD to step backwards, and Mr. Henry punching MD happened at a point where Mr. Henry already believed that MD had a weapon. Ms. Green's testimony was that MD had his hand in his pocket and appeared to be holding something. But it wasn't just that Mr. Henry believed that MD had a weapon. It was the moment of MD stepping forward and putting his hand out, that in that moment that Mr. Henry instantaneously hit MD. But what happened after that is also important as to the reasonableness of this. Again, Mr. Henry came into this trying to stop a physical altercation. So to then hit somebody, there had to be some reason. He did not know MD. He went there to talk with his Reynolds. He had never met MD before, so had no belief that MD was going to be there. But immediately after hitting MD, he hit one time and stopped, and he fell to the ground. But then Mr. Henry went to go help him up and immediately said, I don't play about my life.
Well, so he doesn't play about his life, but he's theoretically hitting a guy who maybe he thinks has a gun. Is that what? Like the inference is he's got something in his waistband and maybe he's going to shoot him, so he punches him in the face. Doesn't seem objectively reasonable.
I don't think it's just that there was a potential weapon in MD's waistband. It was the act of MD stepping forward, raising his hand, and in that exact moment, that's culminated in Mr. Henry hitting MD, not just seeing what he believed to be a weapon from MD.
Does the fact that MD was wearing pajamas, does that make his belief less reasonable that MD was carrying a gun?
I don't believe so. I think, a weapon can be concealed in pajama pants. Here, the most credible evidence and consistent evidence is that Mr. Henry believed that he had to act in self-defense, and the trial court did find that. He immediately made a statement to MD. He doesn't play about his life. MD's mother came outside shortly after, and MD indicated that he felt threatened and intimidated by MD. Mr. Henry himself called the police, even though the police wouldn't have had his last name, and in 2 phone calls, first indicated that he felt threatened by MD, and then the second phone call specifically said he acted in self-defense. And so those all support not only the subjective belief of Mr. Henry, but also that his actions in that moment of Mr. Henry having a weapon, stepping forward, and putting his arm out support this. And MD's own testimony was that his arms went out wide like teeth. And so even if that was a mistaken belief, it was both objectively and subjectively reasonable under the circumstances. And if there are further questions, then I will reserve.
Thank you.
Hey, police report. The court knows this was a trial on the bench. It was not a jury trial, and it resulted in a misdemeanor assault. Mr. Henry is seeking community control, which is essentially probation.
Can you address the trial court's statement there were 2 innocent people here? What do we make of that?
I think what the trial court was trying to do was cut right to the chase. And what he was referring to, I believe, is Henry, perhaps, and to the victim, MD. And when you got to remember also, too, so I think he's referring to Henry and MD because they were not involved in the fight. MD came and got between the 2. One was his sister, one was acquainted with his sister. And then Henry is involved because the mother of the child was green. And what happened, I think, with 2 innocent people is it seemed like there was a de-escalation to the fight. And if you Henry's testimony, then what happened is Henry said something like, if I can't hit the two of you, I can hit you, and he kind of pulled back on MD and then struck him in the face 3 times. MD immediately went and informed his parents and went to the hospital. The injuries were documented. But we also can't forget Officer McKay's testimony because Henry at first denied the assault and then called back later with his mom on the phone and admitted to it. He said that he thought that.
So is the state's version then that the self-defense is kind of an after-the-fact justification of the fight that happened?
That's exactly what it is. That's what that statement is. And even his own witness, when Green testified, said, I know he had something in his pocket, but we don't know what that something is that's being referred to. And so there was no justification here for Henry to use that type of force on MD. There was no provocation. There's no evidence that MD had anything in his pocket at all, or certainly not any kind of weapon. And
MD
so,
was a juvenile?
the junior was 16
And
years
Henry
old.
was how old?
Henry was a little bit older, but must have been an adult just because the transcript referred to Henry as Henry. But I didn't get the impression that Henry was much older than MD when I read the record. There's something in it that gave me that impression.
But the trial court has the opportunity to perceive these people and whether or not one might be physically more intimidating than the other. We only have the transcript to look at.
And that's the point. And all the elements are met element of assault. There is no provocation here. And when we're talking about use of non-deadly force, as opposed to the other case, the only element difference is that you have to use proportionate force if you're defending yourself. You can't use more force than is reasonably necessary. That's not an issue here because MD didn't use any force, which is sort of attacks. I don't know why Henry did that, but I think it was because tensions were high. Maybe prefer because there was sounded like a pretty significant argument.
And so your argument is that Henry was the first and only aggressor in the situation?
Yes, that's our argument. Distilled to it.
And really the trial court only needed MD's testimony to reach that conclusion?
Yes, and I think the trial court, when finding Henry guilty, pretty much stopped the trial court said. So we have the photographic evidence, and we also have Officer McKay, which is somewhat relevant.
Does it matter that the trial court discounted Ms. Reynolds' testimony?
No, not at all. Right. MD's enough, and you couple that with the photographs and Officer McKay's testimony, and you clearly have an assault here, a misdemeanor assault, thankfully. Fortunately, MD's jaw wasn't broken, and it would have been more serious to the performance assault. So we've seen that happen before, with a punch, with a close fist. So fortunately, MD made out all right on the injury front anyway. Could have been much worse. Could have been a felony. It could have been like a felony assault. His jaw was broken. He would be more seriously injured. Because it doesn't look like MD. There's no evidence that he could have been. So we would ask the court to affirm the conviction and the finding of the trial judge. Thank you.
Thank you.
In regard to what would actually be the third element of self-defense, whether this proportionality element, it's not proportionality to the actual weapon, but to the perceived risk. Often, this element comes down to
court didn't really make a credibility determination, but it seems like, as we've listened to this, that the bottom line is the court determined that MD was more credible in this circumstance because it seems like the trial court credited MD's version of what he was doing in regard to trying to de-escalate and found Henry's version not credible based on these circumstances. How do you square that determination with our deference to the credibility determinations of the trial court?
By the trial court finding that many of the witnesses were not credible. And although the trial court specifically talked about Ms. Reynolds and it was the little girl that came in here in line, by using the term many, had to involve more than two. If the court meant, just two of the individuals, the court would have said that. By saying many, it seems to imply MD, Ms. Reynolds, as well as some information from Ms. Green, such as, for example, her getting in and out of the car throughout this situation.
Why would the trial court disbelieve all of these witnesses and then subsequently convict Henry?
That's a good question. With the burden shifting analysis, the court, I believe, felt because there was some injury, the court had to do something. The court did engage in an analysis of whether any kind of lesser included could be an option. Determined it wasn't because there was physical harm to MD. But there was some reason that Mr. Henry changed the whole purpose of him being there and acting, which happened only when MD stepped forward and raised his arm. Mr. Henry did not go to that house knowing MD. He didn't know he would be there. And there was nothing to show that he had any kind of anger. Mr. Henry was the level-headed one throughout the situation up until that moment in time.
How is it level-headed to bring these two combatants together? How does that not cause the affray that led to this whole thing?
In hopes to try to resolve this dispute because Ms. Green had gone over, Ms. Reynolds had gone over to Ms. Green's house and was threatening her. And Ms.
I understand, but
Green was afraid.
before Mr. Henry drove Ms. Green to the house, the two people who had the argument were not together, correct?
That is correct.
And had Mr. Henry not drove the one combatant to the house, this whole incident would never have happened.
This incident wouldn't have happened, but what seems clear from the transcript is that because of Ms. Green's fear, that's what prompted them to go over there. There is also no evidence that Mr. Henry knew anything about Ms. Reynolds or would have known her address to get to the house. So even though there were no questions to Ms. Green about the specifics of going over there and how that happened, clearly an attempt to try to resolve this.
By bringing the two people who wanted to fight closer together.
With other people there to try to dispel what was going on, to prevent some other Ms. Green or child or unborn child from being injured.
And if he would have just convinced Ms. Green and her unborn child to stay where they were, this incident would never have happened.
The incident with MD as well as, MD wouldn't have come outside if this wouldn't have happened either. And perhaps the analysis would be different if Ms. Reynolds was the person who was hit, where the other purpose was to talk to Ms. Reynolds. But MD was not part of the equation of any purpose of going into that house. But the concern was for Ms. Green of the fact that Ms. Reynolds wanted to fight with her and was threatening her that something was going to happen there. And so hoping to explain what was going on seemed to be the purpose.
Counsel, you're out of time.
Thank you, Your Honor. We would ask this court reverse the trial court's finding and discharge Mr. Henry. Thank you.
Thank you. Thank you both for your advocacy this morning. We will take the matter under submission and issue a timely decision. Our last case is C-25-0148, in re guardianship of Dixie Faust. We'll give the attorneys just a moment to get settled. You may come forward when you're ready. Would you like to reserve time for rebuttal?
Yes, ma'am. 5 minutes, please.
All right.
Good morning. May it please the board, council, Walnut Hill students. My name is Chris Pagan. I represent Christian Gunselman. We have a guardianship case here today. The guardianship issue before you is the veto standard with respect to a nominated guardian from a power of attorney. I'd like to address the standard of review first and then go right into the legal standard that I claim has 2 statutes that are in conflict that requires resolution by the court. Generally, in guardianship cases, there is great deference that's applied to probate court decisions. And I would concede that the standard of review here is abuse of discretion. However, I have a legal claim. And for many, many years, and I've practiced for many years, we would see abuse of discretion cases where there would be case law that says abuse of discretion has to be something more than a legal error, but I think that no longer is the law, thankfully. And in 2021, the Ohio Supreme Court, in the Abdullah case, finally clarified that and held that legal errors, or a court has no discretion to violate the law. And therefore, when there is a legal claim or a legal error, that can satisfy the abuse of discretion standard. So as I sit here today, my claim is that there was a legal error that was committed below that requires this court's attention. And that's how we would satisfy the abuse of discretion review that we concede applies. So, the legal error is this. There are 2 statutes that supply the standard for how a probate court is to deal with the circumstance in which an individual has nominated a proposed guardian in a power of attorney.
Counsel, I know that you're about to talk about the nomination and the appointment statutes.
Yes,
I want to cut to the chase on the appointment statute. As I read that statute, it creates a rule that helps a court decide between a nominated guardian that a person might nominate for themselves, and then a guardian who comes forward and nominates themselves.
I think that's fair.
It does not help a court decide between its own selection of a guardian, which is what occurred here. So why does this appointment statute apply?
Well, I have not thought of that, but the way I would handle that is I would step back and I would say that I think public policy in Ohio is reflected in the appointment statute. And it gives autonomy and authority to an individual when competent to make the most important decisions in their life if they become incompetent and incapacitated. And it is incumbent through the nomination and appointment statute for the court, the probate court, not just to have the authority and full discretion to appoint whoever it chooses, but it first has to look to who the proposed board has nominated and then make a determination that they're unsuitable, as opposed to having the authority that I don't think is present in the nomination and appointment statute to do what it wants to do.
And as I understand your argument, you want us to take the language from the appointment statute, this competent, suitable, and willing to accept the appointment standard. You want us to take that and equate it to the good cause standard in the nominations statute. Am I understanding that correctly?
I would say it a little bit differently. I would say that there are 2 standards and both apply to how a court can veto a nominated guardian, and they have different rules. And I think that you have to first determine whether or not you can read them together to create one standard. And I think you can. So the nomination standard, the nomination statute talks about you shall appoint the nominated guardian unless there's good cause shown or disqualification. In contrast, the appointment statute says you have to appoint the nominated guardian if that nominated guardian is competent, suitable, and willing to accept. Good cause versus competent, suitable, and willing to accept.
All right, so you want us to harmonize these 2?
I do want you to harmonize.
All right, as I look at the nomination statute's legislative history, that appointment statute language, which we can maybe shorten for ease of referring to it as the competent language.
Sure.
That competent language used to be in the nomination statute, and it was written out. So why would we write back in or harmonize back in language that the legislature has now expressly rejected?
Because if you don't harmonize it, then you have two statutes that send you in two different directions, and that is a recipe for chaos. And so I think
Well, the legislature didn't think so because it took the language out.
it's true that they might have made a conscious choice, and it's true that they might have made an error. I don't know whether or not. I think that if they had made an intentional choice, they would have changed both standards so that they equated to one another, since they both applied the same subject matter. They did not do that. So whether or not they did it intentionally or not, I think we have to reconcile it. And you have to reconcile it under the rules of statutory construction to give both effect, if you can, to avoid a conflict, if you can, and to promote the overall policy.
Well, in this case, wouldn't we be able to reconcile all of this by following the trial court's order that there was good cause in that there was this self-dealing that was discovered, and that the appointment statute wouldn't apply because the trial court was making its own selection of a guardian?
Okay, well, there's a lot to unpack in that, so we can hash it out better than what I might do here. But first, I would push back on the fact that the trial court applied the nomination statute, the good cause language, in the appropriate way. It did not, if you read the decision, it did not hold that there was a good cause to veto my client's nomination. Instead, what it said was that the magistrate had good cause to act how he did, which is not engaging in an independent analysis, as probate courts are supposed to do when they receive objections, and saying, well, I think what the magistrate did was okay. But what the standard says, what the statute says, is you have to see if whether or not my client, there's good cause to veto what Dixie Faust said she wanted and what my client was obligated to do under the term.
Dixie Faust wanted her stepson to self-deal with her estate.
No, she wanted him to, no. She wanted to manage her affairs. She wanted him to be, because she knew him.
She wanted him to buy a property in Colorado and a $150,000 car for himself.
You know, what she wanted was for somebody to respect and engage the property that she accumulated when she was competent and not incapacitated, and to be able to grow that so that there would be medical services provided to her over the rest of her life.
How did the purchase of the $150,000 car help to grow those assets?
It did not, but the Colorado property, it's accumulated. It was purchased for $500,000.
Okay, but I'm speaking of the car.
The car did not help Dixie Faust, except to the extent that both the power of attorney that she executed with the advice of independent counsel and the two trusts that she approved in her estate plan, all three have provisions to permit the agent or the trustee, here there were two co-trustees, to pay themselves for the work that they did. And if you read the record as close as I hope you do, you would see that my client, Christian Gusselman, spent enormous amounts of time and effort in growing her estate and taking care of her and making certain that she got in a great facility, making certain that she had care through a geriatric psychiatrist, occupational professionals, and the like. And it was extraordinary work, and he paid himself for it.
And did he submit any kind of hourly timesheets, any invoices to justify $150,000 for his work as a guardian?
No, but he was not given the opportunity to do it, although he said that he would offer up the timesheets, and he does have them available, but they weren't presented as evidence and were asked to present it.
Because he, in fact, hadn't actually earned this. I believe his testimony was he has prepaid himself for anticipated work as a guardian. Is that right?
I think that's what he said. That's fair.
Was there evidence about how your client became the power of attorney in the first place?
Yes.
Or her competence at the time?
Yes. The geriatric psychiatrist who testified at the trial stated that she was competent in 2020 when she executed the estate plan and included the power of attorney. She had an independent attorney. His name is Stuart Sustain. You might know him from Walnut, who was her attorney and who drafted the power of attorney in the trust. And I don't think there was any dispute that he gave her appropriate legal services and that she was competent and that she made her decisions to nominate my client, both under the power of attorney and also trust. So,
Can I ask a question about
Yes.
the property in Colorado? And I was looking for this in my notes, but that property was not held in the trust, was it?
it is now. It wasn't
But,
initially.
so he bought it under his own and his wife's name,
He did. And so there were two
using Ms. Faust's money.
He used his money to buy a parcel for himself and his wife. He used Ms. Faust's money to buy a different parcel. And he-
Under his name.
Under his name. And that had to do with complicated rules about Colorado property law and platting and the like. And it was a quick sale, and so he acted quickly and used his own money to buy his parcel. Used Dixie's money to buy an investment parcel. And then when he was able to have things settled, he transferred title for Dixie's Colorado property into the irrevocable trust.
And the
That's
car
what-
the car was also purchased in his own name, right?
Yes.
Using
That's the
Dixie's
services that he
using
bought.
Dixie's money.
Well, it came from Dixie's assets, but it was payment for his services over the period of time.
Prepayment.
Payment and prepayment. So I think the car was purchased in 2024. He took this office in 2020, and I think that he said, I would pay myself $15,000 a year. It was $150,000.
Counsel, you're out of time.
Thank you.
Thank you.
May it please the court. Counsel's argument is that the court omitted the rules and the analysis required. They omitted the test to overcome the nomination statute as far as incompetent, unsuitable, or unwilling. But clearly, the court did make a finding of unsuitability because of the self-dealing. Even though they didn't use the word unsuitable, the magistrate went into great detail about the messy and suspicious transactions. And then the judge, in reviewing the magistrate's decision, said that the magistrate determined that such findings called into question whether Mr. Gunstman could serve the ward's best interest. Clearly, that's unsuitability.
Does that create good cause to bypass the nomination and appoint a separate guardian?
He found good cause. If the applicant is determined to be unsuitable because they're not acting in the ward's best interest, then that's good cause.
Does it need to be labeled as good cause? Does it need to be labeled? Does the trial court need to say, this is the good cause that I'm finding, or can it just describe the facts?
I don't think they have to use the words good cause and the words unsuitability. If what they're saying, if that's what it is, then even though they didn't use those exact words, I think you have to respect their decision.
In probate court, is it the practice of the trial court to simply adopt the magistrate's decision? For example, in common pleas, sometimes the common pleas court will simply adopt the magistrate's decision. My understanding is here, the trial court, the probate court judge basically said, this is good cause, and wasn't very precise. Did it adopt in full the magistrate's decision?
No, the court reviewed it independently. It didn't just adopt it. And the judge went into detail about how he decided that he agreed with the magistrate that someone else should be the guardian of the estate, but he disagreed with the magistrate as far as who should be guardian of the person. And he overturned the magistrate's decision and said, the brother, my client Randy,
what are the differences in the duties between the guardian of the estate and the guardian of the person?
The guardian of the person is someone who takes care of the person. They see that they're cared for, that their living arrangements are correct, that their medical treatment is correct. Guardian of the estate, they're the people that take care of the money.
I have some questions about this nomination statute. These are kind of dense questions, or complex questions, so please bear with me, but I'm hoping you can help me understand this nomination statute. So as I look at this good cause requirement, it's in subsection B of the nomination statute. And subsection B talks about what happens when a person who is planning their estate plan, or what happens to them as they age, when they create a nomination of an initial guardian, someone that they might want to be their guardian when they get older, and then they revoke that by issuing a second or third or fourth or fifth nomination. And when they create that second or third or fourth one, that automatically revokes the first one. And subsection B tells a court, in looking at this lineup of nominations, 1, 2, 3, 4, 5, that the court is supposed to go with the most recent nomination. And if it doesn't, it has to have good cause to go with the earlier one. So the good cause requirement, to me, comes from this ordering which one in time the court is supposed to pick, not whether the court is supposed to have good cause if it rejects any nomination and goes with a third party. Are you following the nature of my question?
Yes.
Does the court need good cause anytime it rejects a nominated guardian, or does it just need good cause when it picks between first, second, third, fourth, fifth?
The judge needs good cause, which means a finding of incompetency, unsuitability, or unwillingness, anytime it deviates from the person you have nominated. So, to find good cause, he just has to determine one of those three things.
Are there any court decisions that interpret the statute that way?
Pardon me?
Any court decisions that interpret the statute that way? That good cause is needed anytime a court bypasses a nominated guardian?
Yes, I believe so, yes.
Any from our court?
Right.
There are decisions from our court that interpret it that way?
I'm not aware of any, but that seems to be a plain wording of the statute that you have to follow. I'm not aware of any exact decisions, but
All right. And do you believe good cause exists in this case?
good cause just means you have to have a good reason, and the court found that because of all this self-dealing, that he was not acting in her best interest. If a guardian come out acting in the ward's best interest, that's alone is good cause to reject.
Is there any difference in the investment in this real estate versus investment in something like a CD or something that would be maybe considered less speculative?
I believe there is, because if you invest in a CD or stocks or bonds or anything, the assumption is that money is there in case they need it for their nursing home expenses, which are anticipated to be a lot over a long period of time because she's physically healthy and mentally, she has dementia. If you go and invest in something that doesn't really benefit the world, but it conveniently benefits you, then you're acting in your best interest. You're not acting in the ward's best interest.
What were the circumstances under which Fidelity got involved here? It's my understanding Fidelity somehow held some portion of the funds. Did Fidelity voluntarily insert themselves as a policing mechanism regarding the actions of the councilman?
I believe so. I believe Fidelity saw these transactions and they knew what the account, what the purpose was. They knew what the trust was supposed to do, and they thought that something, it didn't pass the smell test, so they notified the police that they thought the police should investigate this.
So even though he had power of attorney, Fidelity kind of self-policed the misuse of the trust?
Yeah, financial institutions, their legal departments are on top of stuff, and they don't want to get sued for allowing transactions that shouldn't happen. So they have a mechanism in place to monitor that, and if they see something that doesn't look right, doesn't seem kosher, they nominate or they call the police and they say, we think we should investigate, and that's exactly what happened.
How is the compensation for the guardian, how's the reasonableness of the compensation for the guardian determined?
The court they have a schedule of guideline fees. For a trust, it starts at 1.4% per year, and then as the amount gets bigger, the percentage gets lower. So they have a calculation. If you go to their website and you plug in how much money is under the trust management, it will spit out a number. That's a reason they consider a reasonable number.
And was this $15,000 that Mr. Gunselman paid himself or determined that he should be paid a year? Was that reasonable under that formula?
I believe so, yes. I don't know the exact amounts that were in the trust, but I believe that was the amount that was reasonable.
And is this concept of prepayment, is that standard?
No, it's not standard. I've been a trustee for a number of my clients' trusts. I would not dream of taking a prepayment, getting paid before I actually did the work.
Is it illegal to take a prepayment?
I don't know if there's a law against that, but I'm pretty sure that the court would not think that was kosher. That's all I have.
Thank you.
A couple of questions about the investments. Let me address those. With respect to Fidelity, here's what happened with that. The funds in Fidelity, they were in Dixie House Snag. Mr. Kunstman used his power of attorney to take money from Fidelity and to diversify the assets. So the money that was in Fidelity was put into a Robinhood account, into a Charles Schwab account. Some was left in Fidelity. The funds from Fidelity were used by the Colorado man, which was an investment.
So he took money from Fidelity, put it in Robinhood, and then bought real estate in Colorado?
Well, I'm sorry, say that again. So I can
He took money from Fidelity, put it in Robinhood, and then bought real estate in Colorado?
Well, no, he wanted to diversify the assets that were held in
Is
Fidelity.
this information in the probate court record?
Yes,
Okay, thank you.
yes. In the second hearing, he explained all this. So the money was taken from Fidelity, it was diversified into different accounts, it was diversified by buying real estate, there was a Roth conversion, and there were taxes that were paid. They were concerned about the money dropping, but his explanation was, I wanted to diversify. And the point of it is that, and this is in the record as well, he grew the assets from $1.5 million to $2.5 million. He did that on his own work. And so his investment, well, maybe buying real estate isn't something that we would do, it's like he did, and it grew.
But the real estate was not under Ms. Faust's trust.
It is now. It
No,
wasn't
but
initially.
when you say it grew under Mr. Gunselman's ownership.
But the delay in the title had to do with Colorado land use law, and platting, and those kinds of things.
Well, let me back up to the Fidelity. The Fidelity account was in Ms. Faust's trust.
No, it was in her personal name.
Okay, well, it was her property.
It was her property.
And your client took that property and then put it in a Robinhood account
In her name.
in her name.
Right.
And at what point did it go into his name? Is that when he bought the real estate?
He used the, yes. When he bought the real estate, entitled it in his name for a period of time, and entitled it into an irrevocable trust. Later, where she is the beneficiary.
He bought the real estate using her money in his name. That, at least the initial part of that transaction, he used her money to buy property for himself.
There were two purchases. He never used her money to buy his property. He used her money to buy her property titled in his name, but transferred back to the trust a little bit later.
Did he transfer the property back to the trust before or after the police investigation?
Well, it was in the process of that. So it's a little bit unclear on the record, so I don't know that I have a good answer.
All right. Can you address my question about the origin of the good cause requirement and how we should interpret the nomination statute?
Yes. So, I mean, if you come to a holding like that's based on the question, so it's just an ordering statute, then the court here misapplied the law, because then the appointment statute provides the standard, because this isn't an ordering case. The only person who has ever been nominated to be her guardian in the first power of attorney in 2011 and in 2020 was Christian Gunston. So there's no ordering issue at all in this case. So that statute is, and that's a good reading, I think. And if that reading turns out to be the law, then the probate court here misapplied the law, because this wasn't an ordering case. And then by default, what should have applied was the appointment statute, which goes to competence, suitability, and willingness, which the probate court didn't identify or even apply. The problem that I have in this case, and I feel like it hasn't been talked about enough in this oral argument, is in the probate court, there was no consideration for a presumption of appointment to Christian Gunston, because that's what Dixie wanted and put in her documents. It acted as if it had the authority to do whatever the heck it wanted, and that's not what the law is. And
do you agree that that's some form of rebuttable presumption, and we're debating what the rebuttable standard is?
I would agree that we're debating what the standard is. And I would argue to you that no standard was ever applied below, and that's where the legal error is. This case needs to go back to you need to clarify. If nomination is just an ordering statute, so be it. Then the appointment clause statute applies, and this case needs to go back to the probate court to apply in the first instance the competence, suitability, and willingness standard that it never even addressed.
Counsel, you're out of time if you'd like to wrap up.
I'm wrapped up. I think the case needs to be remanded. I think we need to clarify the veto standard for nominations. Remand this case so the court can do it. The probate court can apply the law in the first instance. Thank you.
Thank you. Thank you for your advocacy this morning. We will take the matter under submission and issue a timely decision.